All right, so get ready for a deep dive today into where law and philosophy kind of like crash right into each other. We're talking tort law,
hmm
and we're going to approach this like a philosopher would.
Yeah, it's not just about, the rules and the cases, but like the why behind it all, the big ideas.
Exactly. And lucky for us, we've got the Stanford Encyclopedia of Philosophy's entry on theories of the common law of torts as, like, our guide.
It's like having a legal philosopher, right there with us, whispering all the secrets.
Okay, so before we go full-on philosophy nerd here, let's quickly set the stage for anyone who's maybe not totally up on tort law. So basically, it's how we handle situations where one person harms another and there's no contract involved.
It's like that in-between zone, right? You got contracts where you agree to stuff and criminal law where it's like society as a whole, the state bringing charges, but torts, it's just person to person.
Right, so things like someone slips on a wet floor in your store, or you spread rumors that really damage someone's reputation.
Stuff that causes real harm, physical, emotional, financial. Tort law figures out who's responsible and how to make things right.
And that's where the philosophy kicks in,
Yeah.
right? Because there are so many ways to approach those questions, like who's to blame and what do we do about it?
Absolutely. And the Stanford Encyclopedia starts right off the bat with two, fundamental questions tort law is always wrestling with. First one, what behavior can we actually demand from each other, even if we don't have a specific contract? Where's the line?
Yeah, it's like even if we're all just strangers, there are still these basic expectations about how we should act.
Exactly. We expect people to be careful, not go around hurting others on purpose, be honest. And that's where the different types of torts come in: negligence, battery, fraud, all that.
But this is where things get really interesting, right? Like, tort law protects certain things, but not others. It protects, say, my safety and my stuff, but what about my financial security?
That's a huge question. Why those particular lines? Like, why is it a tort to punch someone, but not to, I don't know, dump them and break their heart?
Right. That's a good point. It really makes you think about what we value as a society, what kinds of harm we think the law should step in for.
And that takes us to the second big question the Stanford Encyclopedia brings up. When things go wrong, whose job is it to fix it? Is it just about making the victim whole again?
Which, as anyone who's ever tried to put a broken vase back together knows, isn't always possible.
Exactly. So, is it about punishing the person who messed up? Is it about making sure they don't do it again? Or is there something deeper going on?
Maybe something about restoring fairness between the people involved, like a sense of balance or something.
That's the idea behind corrective justice, which is one of the theories we'll be digging into. It's saying tort law isn't just about money. It's about righting a wrong, restoring a moral equilibrium.
Ooh, okay, I'm intrigued. But before we get there, let's talk about Oliver Wendell Holmes Jr. He had some strong opinions about this whole tort law thing.
Holmes, oh yeah, a real legal rock star. In his book, The Common Law, he argued that compensation can't be the main point of tort law.
Hold on, really? That seems kind of counterintuitive. Why wouldn't making the victim whole be the driving force?
Well, Holmes pointed out that using lawsuits to perfectly compensate everyone would be a total mess. Think about it. Suing for every little inconvenience, every fender bender. The courts would be completely swamped.
Yeah, and think about all the legal fees, all that.
Yeah.
Could end up costing more to go after a claim than you'd even get back.
Exactly. Holmes was saying the real point of tort law is to set standards of behavior and hold people accountable when they cross the line. Deterrence, making people think twice before they act carelessly or, recklessly.
So it's less about making the victim feel better financially and more about sending a message to everyone like, hey, actions have consequences. We'll hold you responsible.
Precisely. Holmes was skeptical of too much emotion in the law. For him, it was about clear rules, a stable social order, not just about coddling victims.
It does make you wonder, though, does making someone pay money actually stop them from doing something wrong again? Or is it just, like, satisfying our desire for revenge?
Ooh, that's a good question. And it goes right to the heart of the debate about whether tort law should be about punishment, deterrence, or, some mix of both.
It seems like Holmes was leaning more towards deterrence. But what about other philosophical perspectives?
That's where things get even juicier. Because corrective justice, it gives us a totally different way to think about what tort law is for.
All right, I'm ready to jump into this corrective justice thing. What's the main idea?
Picture this. You got a set of scales, perfectly balanced, representing the moral equilibrium between two people. One person commits a tort, they act careless, they break a duty, and boom, the scales tip out of balance.
Okay, so corrective justice is about restoring that balance,
Yeah.
right? Making things fair. again, between those two people.
Exactly. It's not about, some big societal good or punishing evil in some abstract way. It's about fixing a specific injustice between two people, restoring that moral equilibrium that was there before the tort happened.
I like this. It feels more, I don't know, personal, I guess. More focused on the actual relationship between the person who was hurt and the person who hurt them.
That's a key part of corrective justice. It's not about some big societal goal like preventing future bad stuff. It's about this one specific imbalance between two individuals.
And it's interesting how that lines up with how tort lawsuits work, right? You've got the plaintiff, the person who was harmed, suing the defendant, the person who caused the harm.
It's like a one-on-one duel, right? The focus is on those two people and their relationship, not society as a whole versus the bad guy.
This is making me see the whole purpose of tort law differently. It's not just about punishment or paying money. It's about restoring a sense of fairness and balance.
And that leads to another question. Does this focus on just the individual relationship make sense intuitively? Is that a satisfying way to think about justice? Or does it seem too narrow?
That's a great question to sit with for a bit, and maybe our listeners can ponder that too.
Definitely. Because there are other theories out there that look at tort law through different lenses, like economic analysis, which, as you might guess, brings a very different perspective.
All right, let's talk economic analysis then.
Get it?
Doesn't sound as philosophically exciting as corrective justice.
It might sound a little dry at first, but trust me, it's got some real insights. The economic approach sees tort law as like a tool for making society safer and using resources efficiently for everyone, not just the two people involved in the case.
Okay, I'm starting to see how economics fits in. It's about incentives, right?
Right.
Make it expensive to cause harm, and people will be more careful.
Exactly. Remember Guido Calabresi's idea of a societal decision for accidents? We accept that certain things, like driving, have risks.
I mean, if we tried to eliminate every risk, we'd never leave our houses.
Right. So the economic approach says that tort law helps us find the right balance. It makes people think about precautions because there is a financial cost if they don't.
So if a company knows they could get sued for a faulty product, they're more likely to invest in, quality control.
Precisely. And that leads to the idea of the cheapest cost avoider. Whoever can prevent the harm most efficiently for the least money should be the one responsible for doing it, even if they didn't technically cause the harm.
So it's not just about who's morally at fault, but about minimizing the overall cost of accidents for society.
Right. And it might seem cold-blooded at first, but this economic view makes us think about the big picture. How do our decisions about tort law affect society as a whole?
Are we okay with some level of risk if it means progress and innovation? Where do we draw the line?
Those are exactly the questions economic analysis forces us to confront. It shows the tension between individual responsibility and the good of society.
Wow, this is really giving me a whole new way to think about tort law. It's not just about righting wrongs or punishing bad people. It's also about how we shape behavior and manage risk as a society.
And that's not even all of it. We've got another theory to explore. Civil recourse theory. It's kind of similar to corrective justice, but with a twist.
Okay, tell me more. What makes civil recourse theory different?
Like corrective justice, it sees torts as, fundamentally, about one person harming another. But it's different when it comes to the purpose of the remedy, like what the law does about the harm.
So it's not just about restoring balance, like corrective justice says.
Not quite. Civil recourse theory says the point is to give the victim the power to do something about it, to hold the wrongdoer accountable, even if you can't, perfectly fix the situation.
I see. So it's less about making the victim whole again, and more about giving them a way to, confront the person who wronged them and demand justice.
That's it. It's about agency, about empowerment. Even if a wrong can't be totally undone, the victim still has a right to seek redress, to hold the wrongdoer's feet to the fire.
So it's not just about money, but about feeling seen and heard, about having the power to say, you hurt me and I'm going to hold you responsible.
Exactly. It brings in the emotional and psychological side of things, which often gets ignored in legal discussions.
I'm starting to see how these different theories all offer different pieces of the puzzle. Homes with deterrence, corrective justice with balance, civil recourse with empowerment.
Each one shines a light on a different aspect of tort law, reminds us that there's no one easy answer to the question of what this area of law is really all about.
And we're just getting started. So many more layers to peel back, so many more philosophical knots to untangle. Stay with us as we keep going with our deep dive into the core of tort law. Coming up next, we're going to tackle that super tricky concept, The reasonable person standard.
Oh yeah, that one's a real head scratcher.
Buckle up.
Welcome back, picking up where we left off, digging deeper into the philosophical side of tort law.
Yeah, it's been like mind-blowing so far, all these different ways of looking at what tort law is really trying to do.
And now we're going to get into the nitty-gritty, tackle one of those concepts that's like both super important and super confusing, the reasonable person standard.
Ah, yes, the reasonable person. Always kind of tripped me up, to be honest. Like, are we all supposed to be walking around with this, like, imaginary perfect person in our heads?
Right. It's such a strange idea. The law sets this bar for behavior, this standard of care we all got to meet no matter what our abilities are or limitations.
Yeah, that's the part that always bugged me. Like, who is this reasonable person? Are they super careful, kind of reckless? And how can one standard possibly apply to, like, everyone?
Those are exactly the questions that philosophers and leading scholars have been debating forever. And the Stanford Encyclopedia brings up a classic case, McQuire v. Western Morning News, that really shows this tension.
Ooh, a good old-fashioned legal case study. Love those.
All right, so picture this. A farmer gets warned that his hayrick, that giant pile of hay, is a fire hazard, like it might spontaneously combust.
Wait, hay can just, like, burst into flames on its own.
Apparently. So the farmer's trying to be responsible, right? He takes steps to reduce the risk, but get this, his actions actually make the risk worse. And of course, the whole thing goes up in smoke.
Oh, no.
Yeah.
He's trying to do the right thing, and it totally backfires.
And to make matters worse, the fire spreads to his neighbors' cottages, causes all sorts of damage. The neighbors sue him for negligence.
And I'm guessing this is where the reasonable person comes in.
Bingo. The court said, yeah, the farmer tried his best, but he still messed up. His actions, even though they were well-intentioned, fell short of what a reasonable person would have done.
So even though he wasn't trying to be negligent, he's still on the hook because he didn't meet this, like, abstract standard of care.
Exactly. And this brings up a big philosophical question about legal responsibility. Is it just about punishing bad intentions, or is it about making sure everyone meets a certain level of care no matter what?
It seems like the reasonable person standard is saying, look, we need some baseline expectations for how everyone acts, even if it's not always fair to every individual.
Right. It's like we recognize that people have different abilities, but we can't just let those differences completely off the hook when it comes to preventing harm.
But isn't that kind of unfair to people who, like, through no fault of their own, just can't meet that reasonable person standard?
It's a real dilemma. It shows the tension between having objective standards and recognizing subjective capabilities. The law is always trying to balance those two things, holding people accountable, but also recognizing that not everyone's starting from the same place.
It's like those thought experiments philosophers love, like the trolley problem.
Mm.
Where do we draw the line between individual choice and what's good for society?
Exactly. The reasonable person forces us to think about those same dilemmas, but in a very real, legal way.
It's wild how this seemingly simple concept opens up a whole can of philosophical worms about responsibility, fairness, what it even means to judge someone's actions.
And it doesn't stop at negligence either. This tension between what someone meant to do and what the law expects pops up in other areas of tort law, too.
Oh, really? Like what?
Think about the ultra-sensitive plaintiff rule. Imagine someone who's, like, super sensitive to noise.
Okay, got it. So their neighbor throws a massive party, keeps them up all night.
Right. Now, for most people, the party is no big deal. But for this person, it causes real distress, maybe even a panic attack.
So there's actual harm, but is the neighbor liable? It doesn't seem like they were intentionally trying to be a jerk.
That's where it gets tricky. The law usually says, no, the neighbor's not liable.
Wait, why not? Their actions cause harm, even if it was unintentional.
This is where that objective standard comes in again. The law basically says we can't expect everyone to walk on eggshells around everyone else's sensitivities. There needs to be some shared understanding of what's unreasonable.
So even though the ultrasensitive plaintiff is suffering, they're kind of out of luck because their sensitivity doesn't meet this objective standard.
That's the harsh reality in many cases. It makes you wonder if the law, in its effort to be objective, sometimes misses the nuances of individual experiences.
It's like the law is saying, tough luck, you're on your own, to people who might be really struggling.
It's a tough truth, for sure. Shows the limitations of trying to create a legal system that fits every situation.
Seems like we're always going to have this tension between individual circumstances and what society expects.
Absolutely. And that tension pops up in another fascinating and often frustrating part of tort law: causation.
Yeah, Yes, proving that someone's actions actually caused harm to someone else. That can't be easy, especially when there are, like, multiple things going on.
You got it. And causation, just like the reasonable person standard, is way more philosophically complex than it seems at first.
All right, lay it on me.
Hmm.
What are some of the challenges when it comes to proving causation?
Well, in a negligence case, the plaintiff has to show that the defendant's carelessness was the reason they got hurt. It's called cause in fact.
Okay, sounds simple enough, but I
Yep.
have a feeling it rarely is.
You're right about that. The Stanford Encyclopedia gives us some great examples of these causation head scratchers, like what happens when there are multiple possible causes for an injury.
Like, say, someone's exposed to a dangerous chemical in a bunch of different places.
Mhm.
How do you know who to blame for their illness?
Exactly. Or imagine two hunters, both being careless, firing their guns in the same direction. Someone gets hit. How do you prove which bullet did it?
Yikes, that's a tough one. Seems almost impossible to, like, pinpoint the exact cause in those situations.
It can be super hard. Shows the limits of our ability to draw a straight line between an action and its consequences.
So what does the law do when there are multiple possible causes? Do they just give up and say, too confusing?
Not quite. They've got different tests and rules to try and sort things out, but even those tests can run into philosophical roadblocks.
Like what? Give me an example.
Well, one of the classic tests is called the but-for test. It basically asks, but for the defendant's negligence, would the plaintiff have been injured?
So if the answer is no, then the defendant's liable, right?
In theory, yeah. But this test, even though it seems simple, can lead to some weird conclusions in cases of what's called overdetermination.
Overdetermination. Sounds like something I'd read in a philosophy textbook.
Imagine a ship that crashes into two other ships, separate incidents, but both because of the same ship's negligence. Both collisions cause damage, so the ship has to be out of commission for repairs.
Okay, I'm following so far.
Now, if we use the but-for test on each collision separately, things get weird. Because if you ask, but for the first collision, would the ship have been out of commission? The answer is technically yes, because the second collision would still have happened, still requiring repairs.
And you could say the same thing about the second collision. But for the second one, the ship would still have been out of commission because of the first one.
Exactly. So the but-for test says neither collision alone caused the full extent of the downtime.
But that doesn't make sense. Both crashes contributed to the ship being out of service.
You're totally right. And this is where the whole idea of causation gets even more complicated. It makes us think about whether it's always possible or even necessary to find one single definitive cause.
So how does the law deal with these tricky overdetermination cases? Do they just toss out the but-for test and go with their gut feeling?
Not exactly. Courts have come up with different ways to handle these situations. Sometimes they look at whether each negligent act was a substantial factor in causing the harm, even if it wasn't the only factor.
So it's less about finding the one smoking gun and more about recognizing that, like, multiple actions can contribute to what ultimately happens.
That's the gist of it. It might not be as philosophically neat and clean, but it's probably more realistic.
This makes me wonder if our legal system, which is so focused on finding someone to blame, is even equipped to handle situations where causation is so blurry.
That's a deep question, and it becomes even more relevant when we think about mass torts.
Mass courts, you mean those cases with tons of plaintiffs and defendants?
Exactly. Like product liability cases where a dangerous drug harms thousands of people, or environmental disasters that affect entire communities.
In those cases, trying to trace a direct line from a specific action to a specific injury seems practically impossible.
It can be a nightmare. Really pushes the limits of how we think about causation, both legally and philosophically.
Because how do you hold individuals or even corporations accountable when so many different factors might have contributed to the harm? Things they did, things they didn't do, environmental conditions, maybe even just bad luck.
Exactly. It's not as simple as pointing a finger and saying, you did this, therefore this bad thing happened. There's this whole web of interconnected events and decisions that all might have played a role.
It seems like in these massive cases, the traditional way tort law works, with its focus on individual responsibility and one-on-one lawsuits, just kind of breaks down.
That's a key insight. And it's led some folks to suggest we need new ways of thinking about causation and responsibility in these more complex scenarios.
So are they saying we should abandon the whole idea of blaming individuals altogether? Just say, oh, well, it's all just bad luck and move on.
Not necessarily. But they are pushing us to think outside the box, to be more creative about how we assign responsibility when things are so complicated.
Sounds like we're entering some uncharted territory here. And I'm curious to hear more about these alternative approaches.
We'll definitely get into those. But first, let's take a step back and think about the big picture. What do all these philosophical puzzles about the reasonable person and causation tell us about the nature of tort law itself?
Wow, I feel like we've been through like a mental obstacle course exploring all the twists and turns of tort law.
It's really incredible, right? You start with what seems like a pretty basic legal concept, and then boom, you're down this rabbit hole of philosophical questions.
It's like we've been peeling back the layers of an onion, and each layer reveals a whole new set of puzzles and dilemmas.
From Holmes and his focus on deterrence to the whole balancing act of corrective justice, and then the idea of empowering the victim with civil recourse, we've really covered a lot of ground.
And we've wrestled with those like mind-bending ideas, the reasonable person standard, and the whole causation mess. And honestly, I'm walking away with more questions than answers.
That's the thing about philosophy, right? It's not always about finding neat and tidy solutions. It's about making us confront the tough questions and really think about what's going on beneath the surface of our legal system.
And one of the things that's really stood out to me is how much tort law relies on this idea of individual responsibility.
Hmm?
Like it's all about finding the one person who messed up and
Wow.
holding them accountable.
And as we've seen, that kind of focus can get really tricky when we're talking about mass torts, those cases with tons of victims and a whole web of people and organizations that might have contributed to the harm.
Exactly. Like if tort law is really about corrective justice, about restoring balance between individuals, how does that even work when you might have thousands of people who are harmed and it's not clear who's ultimately to blame?
That's a huge question that legal minds are struggling with right now. It's like, do we need to rethink the whole foundation of tort law? Do we need new approaches?
So are we talking about like a complete overhaul of the system, giving up on the idea of individual responsibility altogether?
Not necessarily, but it might mean expanding how we think about responsibility, maybe including collective actors like corporations or even governments, and recognizing that sometimes harm comes from the way a system works, not just from one person's bad choices.
It's like we need a wider lens, a way to see beyond the individual players and understand the bigger social and economic forces that are at play.
Absolutely. And that might mean coming up with new legal tools and mechanisms that go beyond just individual lawsuits and money as compensation.
Maybe something more like restorative justice, where the focus is on repairing the harm and fixing the root causes, not just pointing fingers.
That's definitely worth considering. And it reminds us that tort law isn't set in stone. It can, and it has to, change and adapt as the world changes.
Wrapping up this deep dive, I'm just left with this feeling of like, whoa, tort law is so much more complicated than I ever realized.
It really is, and it shows how creative legal minds have had to be to come up with a system for addressing wrongs and trying to make things fair in a world that's, well, often pretty unfair.
And it's a reminder that the conversation about tort law, about responsibility, justice, and what it means to harm someone, that conversation is never really over.
Each generation has to grapple with those questions in their own way as we face new types of harm, new technologies, new threats to our well-being.
So to everyone listening, we leave you with this. As you go about your life, think about the connections between us all, the duties we have to each other, even if we don't realize it.
And remember that the pursuit of justice, whether it's individual or collective, is a journey, not a destination. We're always striving for it.
Thanks for joining us on this deep dive into the heart of tort law. We hope it sparked your curiosity and inspired you to keep thinking about the intersection of law and philosophy.
And if you want to go even deeper, definitely check out that Stanford Encyclopedia entry on tort law. It's a goldmine of insights.
Until next time, keep questioning, keep exploring, and keep diving deep.